How do criminal defense attorneys get cases dismissed? So that's a really good question. I'm going to assume by that question that what this is talking about is getting a case dismissed pre-trial, right? So getting a case dismissed by either the DA or the judge before having to go through the process of going through a jury trial and then having a jury acquit you of the charges. And so, there's a few different ways that this can happen. Initially, if I get a client and the only acceptable resolution for the case is a dismissal, and that happens actually a lot in my practice, because I live and work in Colorado Springs, and a large percentage of my practice involves domestic violence charges, and a large percentage of my clients are people in the military. And if you're in the military, you cannot get convicted of a domestic violence offense and still keep your occupation. Because in Colorado, if you receive a domestic violence conviction, you are no longer able to have firearms. And for some reason, the military is very keen on its soldiers being able to possess and carry and use firearms. So if you wind up in a situation where it's got to be a dismissal, then there's two ways that can happen. The first route is for the district attorney to dismiss the case. Now that's going to be the toughest route, right? Because somebody filed the case. Presumably it was the DA's office if it was a felony. If it was a misdemeanor, and here in Colorado Springs and El Paso County, the police officer will just issue a summons. But once a case is filed or a person is arrested, there's some momentum going there. And the district attorney is not going to be keen on turning around and dismissing a case right after it was filed. There's a number of reasons for it. I mean, there's going to be some policy circumstances at the DA's office where they don't want to have too many dismissals coming on cases that were recently filed. That's going to upset law enforcement if that's happening a lot. And, it's also just is a situation where, DAs are going to want something in exchange for the dismissal. Frequently a prosecutor, if they're going to plea bargain, it's called plea bargaining for a reason. So they're going to want something for that bargain. At the very least, they're going to want an excuse or justification that they can give to their boss or their supervisor as to why that case resulted in dismissal if they have to answer that question in the future. So to get a prosecutor to dismiss a case, you're going to have to show them one of two things. And so the first thing that you can show them, and what I think is often the most powerful piece of evidence or mitigation in a case, is by coming to the prosecutor and telling them why they don't have the evidence that they need to secure a conviction at trial. And so, ultimately, if you're a DA, and I was a DA for a very long time, when you're looking at a case, the first thing you look at is, if this case goes all the way, if I take this case to trial, am I going to win? And, that's based on your years of experience, it's based on trials that you've done in the past, but it's an important analysis. And if you look at a case, and most of the time, what prosecutors do initially, before they really delve into a case, is they read the probable cause affidavit or the arrest warrant that the police officer filled out, which just has a few bare bones pieces of information in the case. It's just enough for the judge to sign off on the warrant, or just enough to justify the arrest. And that really is the police officer's best version of their case. And so, when prosecutors are initially looking at these cases, they're just looking at the police officer's best version of the case. And so they're probably thinking that they have a better case than they actually do. And so one of the things that defense attorneys do and that I do in every case is look through the evidence in the case before going to the prosecutor, so that when I go to the prosecutor, I can explain to them, hey, these are the holes in your case, and do you really want to go in front of 6 people for misdemeanor, 12 people for a felony, and try and justify why this person should be convicted of this offense when you don't have the evidence? And so, sometimes that kind of genuine, sometimes difficult conversation early on in a case, sometimes that's the best way to get a case dismissed. And I worked really well with experienced prosecutors who have made the mistake before in their career of trying a case that they were told was a loser, from the get-go. And you only get burned on that, once or twice as a prosecutor. You learn your lesson pretty quickly, and you learn that you want to go on cases where the evidence is there and strong. And so, with an experienced prosecutor, you can have that conversation. And so sometimes that's a really good way to get cases dismissed quickly on cases that the DA can't prove. Now, there are other situations where, it's a bit different. Maybe, there's not that obvious situation where you're going to go to trial and it's going to be a not guilty verdict. Sometimes it's a bit more complicated, or sometimes the evidence that's going to exonerate your client or lead to a not guilty verdict wasn't collected by the police, so the DA is not aware of that evidence. And so sometimes that's some legwork that needs to be done by the defense. And so those additional statements are collected by us, or you as the person accused of the crime may have some evidence in your possession that wasn't collected by the police officers. And so sometimes we can get together that evidence and then provide that to the district attorney to show them, hey, this evidence is going to come out at trial that, we're going to provide, and this is going to be the fatal blow to your case. And so sometimes that's enough to get a case dismissed. Now, the evidence provided by the defense is a bit more of a difficult analysis because the defense in a criminal case doesn't have the same obligations that the prosecution does. So the prosecution has to turn over every piece of evidence that they have. So everything that they want to use to convict you at trial. So police reports, body-worn camera footage, witness statements, 911 calls. They have to provide all of that to the defense as part of what's called discovery. In Colorado, the defense does not have the same obligation. So I don't have to provide the district attorney with any evidence that I have, witness statements that I've collected. I can choose to do that, and sometimes I do if it's a prosecutor that I trust to take into account that evidence and to weigh it fairly. But you don't have to. And sometimes, there's a disadvantage to tipping your hand early on in a case and showing that information or that evidence. Sometimes it's more effective to use it at trial when it's going to have the most effect on the prosecution's case, the most sting, and the prosecution's going to have the least amount of time to respond to that. So that's a calculation that you have to make in every case, when to disclose that. But if the goal is a pretrial dismissal, then sometimes it is appropriate to provide that evidence to the DA and explain why that's going to have an extreme impact on their case. So outside of evidentiary concerns, then there's mitigation. In Colorado, there are some procedures that some district attorneys can extend to allow the defendant to get a dismissal on a pretrial basis after completing some requirements. So, we have some evaluations that the district attorney will extend. If they come back in a certain way on certain cases, then they'll dismiss the case. Sometimes there can be mediated agreements that lead to a dismissal of the case, and sometimes it's just a simple matter of having the defendant complete a course or something like that, and then that'll be satisfactory to the district attorney to feel like they got some kind of recourse from the case, and they'll dismiss it at that point. So outside of the DA dismissing the case, then to get to a pretrial dismissal, defense attorneys have to rely on pretrial motions. And what motions are is those are requests made to the court that are made outside the presence of a jury. So during the pretrial proceedings. Normally, once you've already entered not guilty pleas, so said you're not guilty of the charges and set your case for trial. But these are aspects of the case that allege some kind of constitutional or statutory violation, either on the part of the police officers investigating the case or on the DA prosecuting the case, that then request some remedy from the court, and those remedies can be extreme as dismissal of the case. So, things that you look for there are violations of somebody's constitutional rights, so their right to remain silent, their Fourth Amendment right to be secure in their person and property. They can go down to Colorado statutory law and DUIs. We have an express consent right, and so if that's violated, then there can be motions that go to your rights there, and that can request dismissal of the case or suppression of the evidence. And those things can lead to a dismissal. Either the judge can dismiss the case if the violation is egregious enough, and there are provisions in either the statute, the Constitution, or the case law that allow for that, or the judge can suppress evidence that was improperly obtained by the district attorney, and that can often leave the district attorney without enough evidence to proceed forward to trial on. And if they lose their key evidence, then the only thing left is for them to dismiss a case. Why is it that defense attorneys achieve these results more than lay people? Well, a lot of it has to do with the minutia of statutes and case law that we learn in law school and that we become aware of through years of practice. You're not necessarily going to know that a police officer writing a search warrant has to contain enough probable cause in the search warrant to justify searching a home, and that he's restricted to the four corners of that affidavit when the prosecutor is arguing the validity of the search warrant. I mean, these kind of abstract, I don't want to say obtuse, but that is the practice of law, is learning these rules and then implementing them when the issues arise, and being able to spot those issues in any given fact pattern, which a case is. It's just a pattern of facts and laws that can lead to certain defenses or arguments. Being able to spot those and raise those to a judge and obtain a favorable result, that's the art of defense. That's the art of being a lawyer. So, those are the ways that a defense attorney can achieve a dismissal of a case. And if a case is not dismissed pre-trial, then there's always trial. And the ultimate objective you're looking for there is acquittal by a jury. And the obligation that the DA has at trial is to prove the guilt of the accused person to the satisfaction of a jury beyond a reasonable doubt on each and every element that the prosecution has charged the defendant with. So it's certainly not over if the judge disagreed with your motion or if the DA wasn't convinced of your mitigation. Pretrial dismissal is always best, but an acquittal at trial is just as good. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado. I believe in the Constitution, and I want you to know your rights and know the law.